In this video, I'm going to be explaining how criminal defense attorneys get cases dismissed. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested with their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be explaining how do criminal defense attorneys get cases dismissed. And if you're doing research on this, like, you've probably seen a lot of bluster from attorneys about how a case was dismissed because of X, because of Y, because of Z, or just, hey, I got it dismissed. So let's break it down and see how that can actually get accomplished. All right, so the first way that we can get cases dismissed is before court. And this one, especially if you have no criminal history, you have to try, which is having your defense attorney contact the DA's office and see if they will dismiss it before court. If they do that, you have no criminal record, there's nothing to expunge. It is all good. That is the best possible scenario, really. That is what you want. It is actually better than getting the case dismissed at trial, because trial, I mean, now you have the massive expense of it, but also the massive stress for a really long time, where the thing that's going to keep you up at night, and we all have them, the thing for you is going to be a very, very stressful thing, which is perhaps I will go to jail or prison or lose my job and livelihood and my life will be ruined. So if we can get it dismissed before court, that is absolutely the best one, and that is way number one. Number two is, if the case has been filed, to still work with the DA, talk to the DA, try to convince them to dismiss it. Now, if we don't have any hard evidence on our side, this is going to be tough. Sometimes it will still work if the other side's case seems weird. So, I mean, I'm trying to give an example of a weird one. Like, one is like I had like a Home Depot theft case, like grand thefts, where my client was returning things, buying things, whatever, and eventually he ended up taking something that he actually hadn't paid for but thought he paid for. He had no criminal history, and I had him actually ultimately even speak to the DA and let the DA question him because I believed his story, and we did get the case dismissed. So that's one example of something weird. But I mean, I've had cases that are much more serious than that, where, you know, I'm looking and I'm like, well, it doesn't make any sense that my client would have even known that the gun was there because he wasn't sitting anywhere near it. It literally wouldn't have been within his eyesight, and shown pictures of a similar car and shown the DA, like, look, this case is bullshit. You should actually dismiss this one. You don't hear from me saying this about every single case, but for this one, you should dismiss it. So convince the DA that on the evidence it should be dismissed. Number three is to talk to the DA and get the DA to agree to some kind of classes or therapy in exchange for a dismissal. That is called diversion. And that is helpful also if it was a first offense, to get the DA to dismiss the charges and agree, okay, you know what, if you do a bunch of weeks of domestic violence classes or so much therapy or AA or whatever that seems to at least kind of fit, then they will dismiss the case. Now, that can be hard to get. It can require persistence, but that is one way to get a case dismissed as well. Number four is a motion to suppress. So let's say that the cops searched your car illegally, searched your house illegally, searched your person illegally, and found something that was bad. Okay, so if they searched it illegally and we get that suppressed and that was all the evidence against you, then the case will be dismissed. Or let's say that the cops detained you and started asking you a bunch of questions and you felt like you weren't free to leave and they didn't read you your rights, and then you confessed. Now that is an illegal interrogation, and that confession should be suppressed. So if that was the only evidence against you, again, then the case should be dismissed. Number five is, at the preliminary hearing in a felony case, if the prosecution does not, and they most always do, but if they do not show at least some evidence, basically if they don't show that they have probable cause that a crime was committed and that you committed it, then the case can be dismissed. But that one, honestly, don't put too much stock into, because most of the time that is not going to happen. Most of the time the prelim judges are sitting there half asleep, half dead. They are not going to dismiss the case. And there's also a rule called Prop 115, which is basically that if no witnesses show up, a police officer can instead testify as to what they said in the police report. So almost always it's going to pass. It's going to move on from there. Number six is a motion to dismiss after the preliminary hearing, saying that there was something wrong with the judge's decision at the preliminary hearing. As you can imagine, that one it's a 995 motion, that's what it's called. That one has even less chance of success, because now we're saying not only did the prosecution not have enough at the preliminary hearing, but the judge also didn't make the right decision. So that one, We make it in some cases that are serious because it gives you grounds for appeal later, but unless there was something like severely lacking on the prosecution side, that probably is not going to prevail unless there's something really, really wrong with the allegations in the case. Okay, and then the last one, of course, is trial. I mean, we get cases dismissed at trial, and I love going to trial. I do. That is why I'm doing this and why I'm not a contract lawyer working for a big firm. I love going to court. I love going to trial. But I know that there's a big risk for my client, right? I mean, if I get a guilty verdict, I still go back home at the end of the night, at the end of the day. My client doesn't necessarily. So I want to avoid that whenever possible. But if we don't have a choice, so if my client, for example, maybe he gets an offer of felony probation, but he knows he'll lose his job if he has a felony. Even if he gets it expunged later, he knows that he'll lose his job if he has a felony. I mean, we have to go to trial. Or if it is a very serious case, murder case, attempted murder, something like that, where they're not really giving the client an offer, or they're not giving the client an offer that's at all reasonable, then we have to go to trial. And so that's another way. And my trial win percentage is, well, a lot better than the DA's percentage, but I still want to avoid it if at all possible. But it's a way to get the case dismissed, right? You have to convince 12 jurors to vote not guilty. If 11 vote not guilty, 1 votes guilty, it's going to be a mistrial. So I need to get all 12. And mistrial, they can actually refile. It doesn't mean the case is dismissed. So if you're in jail, you might actually be stuck in jail. So I really need to get all 12 on my side not guilty. And that is the final way to get a case dismissed, get charges dropped. If you do have a case in California and you have any questions about it, if you need to book a consultation, you can find my number down below. You can also find a link there to book a consultation directly. I hope that you found this video helpful.